Welcome to the National Crime Victim Law Institute's online toolkit video. This video provides an overview of the crime victim's right to be heard at sentencing and steps to consider when a crime victim is denied the opportunity to exercise that right. A single criminal act may impact the victim's family, and the community, and the impact upon a victim isn't fixed at the moment the criminal act is committed. A victim's physical, psychological, and financial sufferings may last long after the crime is over. The right to be heard at sentencing gives the victim the opportunity to confront his or her offender, explain the harm caused by the crime, and ask the court or the jury to consider the full effects of the crime before it decides on the sentence. Let's quickly review what we mean by sentencing. Sentencing is the post-trial or post-plea stage where guilt has been determined and the legal consequences of the conviction will be decided. Typical elements of a sentence include restitution, incarceration or probation, and fines. Under federal law, crime victims have several explicit rights related to sentencing. They include the rights to receive notice of, to be present at, and to be reasonably heard at sentencing, the right to receive restitution, and the right to be treated with fairness. The laws of the 50 states and the District of Columbia vary, but the right to restitution is a common right, and all jurisdictions provide victims with a right to be heard at sentencing. The right to be heard should not be viewed as merely a right to speak or submit something in writing. It should encompass both an opportunity for the victim to describe the impact of the crime and the process of having the court and the jury consider that information before deciding on the sentence. Three main purposes are served by affording this right. First, it provides an opportunity for victim participation and empowerment. Second, it requires the defendant to confront the human costs of his or her actions. And third, it requires the courts or the jurors to consider the full impact of the crime before deciding on the sentence. When the crime victim is afforded his or her right to be heard at sentencing, what does it look like? The right to be heard at sentencing is usually exercised through the submission of a victim impact statement, which may be presented in written or oral form. Each jurisdiction's law varies on how a victim may present his or her impact statement. Generally, there are 4 ways to be heard, and unless the law states otherwise, a crime victim may utilize more than one way. First, the law generally requires the preparation of a pre-sentence report for certain crimes, and those reports often are required to include a written victim impact statement. Second, the victim, or the state on behalf of the victim, may submit a brief called a sentencing memorandum that includes victim impact information and legal arguments. Third, in some jurisdictions, it is permissible to submit informal letters directly to the court for consideration. Lastly, the victim impact statement may be delivered in person at the sentencing hearing. It is important to know that for purposes of the right to be heard at sentencing, the law may permit more than one person to submit a victim impact statement, and the term victim may include more than the direct victim. It may, for example, also include the parents of minors, relatives of a deceased victim, and others deemed appropriate by the court. What type of information may be included in victim impact statements? 3 categories of information have been identified in case law. First, the victim's personal characteristics. Second, the physical, psychological, and financial impact of the crime. Third, the opinion about the crime, defendant, and the sentence. Federal law makes clear that the first 2 categories are allowed in all cases. The third category is allowed in non-death penalty cases, but the law is unclear as to whether the third category is allowed in death penalty cases. State laws vary with regard to the exact scope of information that may be included in non-death penalty cases, but all jurisdictions permit, at a minimum, the statement to include the impact of the crime on the victim. What if the victim was not afforded his or her right to be heard? Ask the court to undo the sentencing and start over. A case that addresses this issue is State v. Barrett. In this case, a stalking victim was not afforded her right to be heard at sentencing, and the trial court sentenced defendant, the victim's estranged husband, to 2 years probation. After the victim learned that the court had sentenced defendant, the victim asked the court to set aside the sentence and reschedule the sentencing hearing for a date and time when the victim may participate and be heard. The trial court denied relief, and the victim sought appellate review. The Oregon Supreme Court reversed, holding that the victim was entitled to the remedy of resentencing for the violation of her rights. The court specifically addressed the issue of double jeopardy and concluded that resentencing was not barred by the double jeopardy clause. What if you were working on a case where your client, the crime victim, was similarly denied his or her right to be heard at sentencing? What are some of the steps that you should consider if you need to litigate this issue? Let's review a general litigation checklist for this purpose. Before we go over the steps, keep in mind that the law varies from jurisdiction to jurisdiction, and some victims' rights laws may be written in a manner that limits relief for rights violations. Consider contacting NCVLI for technical assistance if you have a case in one of those jurisdictions. We'll walk through this list and then review examples for each point. First, identify the victim's rights that have been violated. Second, identify the proposed remedy. Third, identify the procedure for seeking relief and comply with the requirements. Fourth, assert all possible legal arguments. Lastly, if the victim is willing, seek further appellate review. Let's review each step. A denial of a right to be heard at sentencing often involves other rights violations. Therefore, the first step you should do is identify all of the constitutional, statutory, and rule-based rights that may have been violated in your case. Other rights that may have been implicated includes the rights listed on the screen. Consider, for example, a case where the court didn't order restitution because the victim was denied the opportunity to inform the court about the full extent of his or her losses, such as current and future mental health counseling expenses and lost income. In such a case, the victim's right to receive full restitution was also violated. Second, identify the proposed relief. How the proposed relief should be worded depends on the procedure you're utilizing and the rights that were violated. Third, with regard to the procedure, the rules and timing requirements may dictate which option you elect. Keep in mind that a few jurisdictions have special review procedures that crime victims must follow when challenging a court decision based on rights violations. If you don't have special review procedures, then evaluate the traditional avenues. Next, when evaluating all the legal arguments that should be included in the brief, consider the arguments listed here on the screen. Based on NCVLI's experience litigating victims' rights issues across the country, standing, illegality, and double jeopardy arguments should almost always be addressed. Keep in mind that victims' rights laws are fairly new in most jurisdictions, so while there may be case law that implies a remedy is barred, if it predates enforceable victims' rights, don't be dissuaded from seeking relief. Lastly, consider whether the victim has exhausted all avenues of review, and if the victim is willing to continue, litigate as far as possible. If your state's highest court denies relief, evaluate whether your case raises a federal question that may be grounds for a petition for review by the United States Supreme Court. Ultimately, it is a matter of fairness. A convicted defendant has a right to be heard at sentencing, where defendant, defendant's family, friends, and supporters may all have an opportunity to ask the sentencer to consider defendant's unique personal history and reasons for a lighter sentence. Simple fairness requires that we also afford the crime victim a similar right to be heard and be considered as a unique individual before the sentence is rendered. This concludes our overview of the crime victim's right to be heard at sentencing. Thank you for joining us. Please visit NCVLI's website for additional resources.